Hey, this is Warren Redlick, something a little different today. Going to break down the Twitter dispute between Elon and Twitter. This is Twitter's lawsuit that they just filed against Elon. I'm going to go through the document that Elon filed a few days ago, and then I'm going to go through this document that Twitter filed. Full disclosure, I am both a Twitter shareholder and a Tesla shareholder. If I have a bias, it is very clearly in favor of Elon. I own a small amount of Twitter stock. I own a lot of Tesla stock. I've been an Elon fan for years. I have a lot of complaints about Twitter, but I'm going to try to go through this. I'm going to try to be fair. And ultimately, this is going to come down to what I would refer to as was two things. One, there's this question of fact. Musk's position asserts certain facts. Twitter asserts different facts, and that's the kind of thing that can only be resolved by what's called a fact finder, in this case a judge deciding which story is more credible. And then there's a legal issue related to this question of specific performance and whether there is irreparable harm, whether Twitter has suffered irreparable harm. That's a high standard to meet. As I understand it, and full disclosure also, while I have been a lawyer for most of my adult life, I have retired as a lawyer, and this is not the kind of work I did as a lawyer. I handled one case vaguely like this once when I was working for a judge. It wasn't really like this, wasn't in this much depth. So I know how to read lawyer language, but I'm not like a legal expert on this topic. I've read different lawyers who claim to be experts saying different things about this, so I'm not going to be able to resolve that. But a couple things. There are questions of fact, which means you need a hearing, which means witnesses have to testify, and a judge can decide what he believes. And is there enough to justify specific performance? We'll see. Let's get into it. Are you ready? Let's go. So we're going to start with Elon's filing that was a few days ago. Mr. Musk is terminating the merger agreement because Twitter is in material breach of multiple provisions of that agreement. Fundamentally, I think the main complaint that Elon has raised here, it's hard to read intentions here. The main focus on both sides seems to be this question about whether Twitter complied with Elon's request for information, or whether Twitter had to comply with Elon's request for information. That's the main question that comes up here that I see, but there are other issues. The claim is that their breach of multiple provisions made false and misleading representations upon which Mr. Musk relied when entering in the merger agreement and is likely to suffer a company material adverse event. This is something, the Twitter document hotly disputes all of this, but I just wanted to get into this is Musk's letter that was filed with the FEC, letter to Twitter terminating the agreement, right? So that's the claim here. Let's go deeper. It involves, there's this laundry list of descriptions of Musk's effort to get data from Twitter about daily active users, bots, that type of thing. And there's like several paragraphs. I don't think it was like 5 paragraphs with a lot of depth about all the things that they're saying that Twitter failed to comply with in terms of giving them information. While Twitter, this is the claim, while Twitter has provided some information, the information has come with strings attached, use limitations, other artificial formatting features, which has made the information minimally useful, and an artificial cap on the number of queries. Twitter, as you'll see later, they claim, well, that cap wasn't artificial, and we modified it to make it easier for Musk to do what he wanted to do. So they're disputing pretty much everything that Musk is claiming here. And then then you have this question of fact. What did Elon ask for? What did they comply with? Are they lying when they're saying we gave him everything he wanted, or is he lying when he says they didn't? One of the issues here is, does Musk have the right to the information he's requesting? Twitter's saying you don't have the right to this. I've seen all kinds of talking heads saying, oh, you don't have the right to get this information. The way you wrote your agreement, even Donald Trump is saying that the contract that Elon signed, the agreement that they signed, that Elon made a mistake and shouldn't have signed that agreement. Does Donald Trump know that much about this kind of acquisition? I don't know. Donald Trump seems to know everything about everything, but I don't trust Trump more than I'm probably going to throw them. So the talking heads say one thing, but Musk's claim is he didn't waive his right to review this information, and he specifically negotiated these rights. Twitter's claim is, no, we specifically negotiated that you don't have as much rights as you would have had when you first asked for them. What's the correct answer? I'm not sure. We'll see. In addition to the claim that they didn't provide the information he wanted, they said that Twitter, the merger agreement contains materially inaccurate representations. In other words, Twitter represented some things that were not accurate, that they represented no documents filed with the SEC contained any untrue statement of material fact. And there's this laundry list of, again, another laundry list of things that relate to bots and fake accounts and the actual number of daily active users. Did Twitter materially mislead the public, the SEC, shareholders, advertisers? We can't know that. Twitter has a pretty good response that I find somewhat credible. You know, Elon said that one of his goals in taking over Twitter was to get rid of bots, but I think he was referring to a specific kind of bot. I don't think he was saying Twitter is deluged with bots. The thing they mentioned specifically referred to crypto bots, which is a different issue than the bots generally. So I don't know whether they're on point or not. Again, question of fact, who's telling the truth, who does a judge believe? This is the kind of stuff that comes up. There's this other claim that Twitter did some things with the business, like firing some employees or other things related to employment, other things the way that we're running the company that damaged the business, that would affect the value of the company when Elon takes it over. I don't know whether this is material or not. Twitter, of course, disputes this in their document that I'm going to show you next. So let's look at what Twitter filed. Now, this is going to be the longer part of the video because it's a longer document. This is Twitter's verified complaint. Verified isn't a particularly important concept. Complaint is the document that initiates most lawsuits. Sometimes it's a petition, but most litigation is started with a complaint. In my experience, there are other terms for it, but it's a complaint. And as we know, this is about a binding merger agreement. Let's go into more depth here. What is here? So in April, they entered a binding merger agreement. Now, 3 months later, Musk refuses to honor his obligations to Twitter because the deal he signed no longer serves his personal interest. Now, this is one of the things that struck me about the way Twitter's document was written. Was it's attacking Elon personally, repeatedly, and it's making Twitter look like a victim. This, to me, now again, I'm biased, but this is my read of it. That looks weak. That you make it about attacking Elon personally and you make yourself look like a victim is a sign of weakness. It's a sign of, my opinion. Okay, now maybe it's just a legal strategy. Maybe it's effective. That's more. It almost seems like it's more for public posturing than it is for persuading a judge. That's what I mean by weakness. Like, if I'm trying to persuade a judge, I just lay out the facts. I don't need to say Musk did this to serve. It doesn't matter whether he did it to serve his personal interests. That's irrelevant. This is not important. And he mounted a public spectacle to put Twitter in play. Oh no, poor Twitter. Again, I'm not saying they're wrong. I'm not saying they lose the lawsuit. It's just like, why would you write it this way? This is chicken shit. This is not how you write a document. My approach is, look, if you're winning, if you have great facts and the law is on your side, you don't whine about being a victim. You don't call the other guy names. You don't have to. You just say the facts and you say the law and you win because you've got the stuff on your side. If you need to go to I'm a poor victim and he's a bad guy, that's a bad sign for you. That doesn't mean they're wrong. It could be a strategy. It could be just that's the way that lawyer does things, or that's the way they wanted things done. But that makes me suspicious. As I read the document, I find the Twitter answers to what Elon says. It's one of those things that when you work for a judge, you read both sides. They both make sense. You have to pick one of them, right? I don't know who's right and who's wrong. I don't. And there's these fact questions that it turns on that we can't know. That none of the talking heads, the people you see talking on Twitter, on TV shows or whatever, nobody knows the real facts. And even the people who are saying what they're saying, two people can believe two opposite things happen. What's the Japanese movie Rashomon? So you can just see this spectacle putting Twitter in play. Musk apparently believes, unlike every other party subject to Delaware contract law, he's free to change his mind, trash the company, disrupt its operations, destroy stockholder value, and walk away. It's like it's so whiny and destroy stockholder value. If I'm not mistaken, Twitter's share price has held up better than the rest of the market. Elon's interest in the company, the possibility that a transaction goes through, even if it goes through at a lower price, has held Twitter's stock price up more than it otherwise would have held if it wasn't for Elon getting involved in this in the first place. So the claim that he's destroyed stockholder value, it seems to me he's boosted the stockholder value. As a shareholder of Tesla, this Twitter, I bought Twitter after Elon's interest was announced. I've lost money on my investment, but I've lost less than if I'd invested in other things. So I don't see where he's destroyed stockholder value. Then they claim that Musk has a long list of material contractual breaches that have cast a pall over Twitter and its business. Elon has said some things that a lot of us already believed. I don't know that Elon said anything that, quote, cast a pall over Twitter and its business. Twitter has problems with its business that are well understood now, and maybe we're more aware of it because we're thinking about it. But I don't see how, if it's true, then he's not casting a pall over Twitter and its business. He's revealing the truth about Twitter and its business. So Twitter brings this action to enjoin him from further breaches, to compel him to fulfill his legal obligations, and to compel consummation of the merger upon satisfaction of a few outstanding conditions, blah, blah, blah. That's what they want to have happen. After the merger agreement was signed, the market fell. The value of Musk's stake in Tesla declined by more than $100 billion. So Musk wants out. This, again, is asserting that Elon wants out because of personal reasons or personal financial reasons, rather than Elon is saying this is what's going on. These guys failed to disclose, and he's discovered much more about Twitter now. My gut is that Elon is just trying to negotiate a better price, and he still wants to buy Twitter. I don't know, but so Musk wants out. Again, there's this tendency to disparage Elon. They're angry, they're whatever, but the whole comedy of this thing, by the way, that when Elon first started talking about buying Twitter, everybody was like, oh, Elon shouldn't buy Twitter, this is bad for Tesla. And when Elon walks away, oh, Elon has to buy Twitter, this is bad for Tesla. Like, everything Elon does is bad for Tesla, supposedly. That's the comedy of the media and the talking heads. Then, again, hypocrisy, these pejorative attacks, to me, weaken your argument. It may work on some judges. Maybe they know the Delaware judges, and maybe this is what works on Delaware judges. I don't know. I'm not familiar with those courts. But Musk's exit strategy is a model of hypocrisy. And this is a pretty good point. I mentioned this earlier, that Musk said that one of his reasons for wanting to buy Twitter was to get rid of the crypto spam, which was a major blight on the user experience. But crypto spam is one kind of spam. Raised a clarion call to defeat the spam bot. So this is an acknowledgement. This is a fair point that Elon was aware of a bot problem when he decided to take over Twitter. That doesn't mean he thought the bot problem was bigger than the 5% that Twitter claimed, right? That just means that bots are a problem. He didn't say Twitter's besieged with bots and it's making it useless and there's a hell of a lot more bots than Twitter said. That this is a suggestion that somehow Elon knew there were more bots, that he knew that Twitter was lying about its bot problem. He knew we were lying. What is this argument? Their claim is when the market declined and the fixed price deal became less attractive, Musk shifted his narrative, suddenly demanding verification that spam was not a serious problem on Twitter's platform and claiming a burning need to conduct diligence he had expressly forsworn. So they're claiming that in the agreement, Elon didn't have a right to diligence. This is one of those issues that I just can't answer the question. Did he completely waive the right to conduct due diligence? I don't know. It's very clear to me that he has the right to get information that will be helpful in consummating the transaction. And it seems to me that people who are financing the transaction, that are participating in the transaction, are going to want to know, were they lying about how many active users they have? I think that that's a reasonable connection, but maybe a judge is going to say, no, that's not a reasonable connection. That's not part of this. You didn't agree to that. They accuse Elon of bad faith. As I read Elon's document, it was just sort of matter of fact. They didn't comply. It wasn't accusing Parag, the CEO of Twitter, of bad faith, or Brett Taylor, the chairman, of bad faith. I didn't see any name calling. Maybe I need to read it again, but I don't recall it being laden with all this name calling and victimization type stuff. It was just sort of matter of fact. They didn't comply with the agreement. They didn't give us the information we needed, blah, blah, blah. And this comes off as whiny to me. I've said that before. So here Twitter is claiming Twitter has abided by its covenants and no company material adverse effect has occurred. There's this, if something particularly bad happens that damages the company, then Musk can get out of the agreement. And they again say Musk has been acting against this deal since the market started turning, breached the merger agreement repeatedly in the process. A whole bunch of a laundry list of things that Elon has his laundry list, right? They have their laundry list of all the bad things Elon has supposedly done. And then they claim they're entitled to specific performance, which means Elon would have to buy the company for the stated share price. They're claiming that they negotiated for itself a right to hire and fire employees at all levels. Elon was saying in their paperwork that they fired 2 key executives, and Twitter saying we had the right to do that. We specifically agreed in our agreement to allow Twitter to make these kind of employment decisions. I don't know enough to know who's right on this point. I don't know whether Twitter's decisions to fire certain people goes beyond what they had the right to do, and I don't know whether that had a material effect on the company. I don't know, you don't know, the talking heads don't necessarily know that. This is the kind of thing that goes before a judge. And they claim that they negotiated to change the definition of company material adverse event or effect so that Musk couldn't. They claim they were worried that Musk was going to try to weasel out of the deal. That's not precisely the language they used. That may not be exactly what they said, but they pushed for certain language in the final agreement to protect themselves from Musk being whimsical, I guess. They wanted to make sure if they were going to do this that it was going to go through. And they claim the conditions to closing are few. The agreement contains various representations by Twitter, including its SEC filings, are complete and accurate in all material respects. This is one of the claims that Elon's making, is that your SEC filings were not complete and accurate in all material respects. There's this question about how many daily active users do you have, how many bots do you have, and if Twitter is misrepresenting to the SEC how many daily active users they have. It's a legitimate, my take is that's a legitimate complaint from Elon. Their take is no, this doesn't rise to the level that you're claiming it does. When Elon's asking for information about bots and daily active users, they're claiming that the information requested must be for a reasonable business purpose related to the consummation of the transactions contemplated by this agreement, and Twitter can decline a request if its reasonable judgment determines that compliance would cause significant competitive harm to the company or its subsidiaries if the transactions contemplated by this agreement are not consummated. This to me is a telling moment where Twitter is basically saying, we don't have to give him the information. We have perfectly the right to not give him the information he says he needs. And I think this is a potential, I don't know how a judge is going to rule. This looks to me like the biggest problem for Twitter. This seems to be the biggest issue that Elon has raised in his documents. Reasonable business purpose related to is very broad. And if we need this information to help complete our financing, then it's related to the consummation of the transactions. It's pretty broad. I read reasonable business purpose related to the consummation as broad. They're trying to say that that's narrow, that no, this isn't really related to the transaction. This is just unrelated. This is other stuff. And I read reasonable business purpose related to as pretty broad. That's pretty broad language. So that, what does a judge think about that? I don't know. Okay, we're in the home stretch here. We're getting closer to the end. Defendant's ability to terminate the agreement before the presumptive drop dead date is extremely limited and carefully circumscribed. While there are closing conditions, there is no right for defendants to terminate unless there is breach sufficiently significant to cause failure of a closing condition. So they're claiming Elon doesn't have the right to just terminate this way, that he didn't give it enough effort, that there has to be due notice, that incapable of being cured. I don't know whether, and they also say defendants have no right to terminate if they're in material breach of their own obligations under the agreement. Now, material breach, in other words, Elon said something you shouldn't say. Is that material? Probably not. And they talk about specific performance is the big issue, right? Suppose a judge rules, well, Elon, you shouldn't have terminated the agreement. There's a $1 billion termination fee. You have to pay him $1 billion. That's not a big deal. If a judge rules you have to buy the company specific performance, which is a heavy lift, and we're going to talk about that in a little bit, that's a much heavier finding. But the practical reality is Elon walking away from the agreement, if he's forced to buy the company, then he hasn't lost anything by terminating. He ends up having to buy the company, and he paid a little bit to lawyers along the way. So there's not a lot of risk here for Elon as I see it. They claim that in their SEC disclosures, they were careful in how they discussed the daily active users, MDAU, monthly daily active users. They said it's not based on any standardized industry methodology, may differ from estimates published by third parties, may not accurately reflect the actual number of people or organizations using our platform. We said we didn't know what the hell we were talking about in our filing. Okay. Based on an internal rule of significant judgment, may not accurately represent. So here's the thing. If they knew that they were not accurately representing it, that would be different. If they just, hey, we weren't very careful and we did the best we could, and I guess we didn't realize there were so many bots, okay. But if they knew that they were misrepresenting, then this isn't enough to protect you. And my gut is they know. They know there's more bots than they're saying. That's my gut. I'm not saying I'm correct. I'm not saying a judge is going to agree with that. I don't know if the evidence is going to show that. But they probably knew when they filed their SEC documents that they had a bigger bot problem than they were admitting, and that they had fewer daily active users. And that's probably true of a lot of platforms, not just Twitter. And this is a common issue in the industry. And Elon probably knew that they knew that. I don't know how much Elon knew. What did Elon know? When did he know it? I don't know. This is again getting whiny. Musk's misleading attacks on Twitter's handling and disclosure of spam or false accounts. I'll just say, I mean, I feel the same way about YouTube. There's a lot of bots and fake accounts on YouTube, and my comments on my YouTube videos. I don't think the fake account thing is as big of a problem on Facebook or Instagram, but I don't spend a lot of time on those platforms. Definitely a huge issue on Twitter. Definitely worse than it is on than my experience on Facebook or Instagram for sure. On May 16th, Musk made the baseless claim that fake users might account for as much as 90% of Twitter's users. Is it baseless? We don't know. He said might. I mean, this is the same thing. You're saying, well, we said we weren't sure. Well, he said might account for. We don't know. He said that Twitter's estimate that where fewer than 5% of daily active users might be a material adverse misstatement. And it might be 4 or 5 times that number. We don't know. We don't know. And this is one of those things. And Elon's pointed this out. Now you're going to have to disclose your bot info in court. A judge is not going to let you off the hook on this information. If this information is material and it's material to the case, if Elon's saying you've got a lot more bots than you're admitting and you're saying you don't, then this is material to the case and you're going to have to prove this in court. And if it doesn't go your way, then you got a problem. There's this ongoing, Twitter has this long description of the ongoing back and forth between Twitter and Elon about Elon seeking information, Twitter trying to get information. There's this claim that Elon made that there was an artificial throttling. It turned out that there was some default limit that wasn't created of 100,000 per month limit on the number of queries that can be deducted. Twitter says that they upped the query limit when Elon asked about it. More than 100 times what most paying Twitter customers would get. What more than 100 times what most paying Twitter customers would get. What do other pay? Are there other Twitter customers who get more? This is kind of an interesting little fact. This is very carefully worded, and if you read Elon's filing, that enterprise Twitter customers may get more than whatever Elon's getting. If that's still true, then that's a problem for Twitter. And the way they worded this makes me think that maybe Elon's statement there is true. Again, this victim status wreaked havoc on the trading price of Twitter stock. Twitter stock's held up pretty well. I don't know what you're talking about. How bad would Twitter stock be if Elon wasn't in the process of potentially buying Twitter? This is just more whininess. But basically their attitude is at a certain point the stock market turned and Elon's trying to get out of the deal rather than Elon having genuine concerns about the bot problem. I don't know. Is it true? I don't know. Is it regardless of the stock market tanking, Elon's just trying to negotiate a better price? I don't know. We can't really answer these questions. Now, this is a claim that because Elon supposedly materially breached the merger agreement, they're barred from terminating it. If you're the bad guy, you don't get to cancel the agreement. This sounds weak to me. I don't know. Did Elon do anything that really materially breached? What does material mean? Material means it has to be more than just a little, right? So does anything he did really significant? Nothing that I've seen. I'm biased. I'm an Elon fan. I didn't see anything that he did that materially breached an agreement, that caused any damage to the company. The fact that they're whiny and their feelings were hurt is not material. Right? That's not enough. Was there serious damage to the company? Did employees quit because of something? Did key employees quit that damaged the business? I don't think so. That's what I think material means. Maybe material means something else. These are again questions for judges. This I think is a big one here. To push for specific performance, Twitter is claiming irreparable harm. In my experience as an attorney, I've seen the claim of irreparable harm before. Irreparable harm is a big hill to climb. It has to be, something that money damages can't compensate for. And I don't know what the standard is for irreparable harm, but usually in my experience, irreparable harm is a very high standard that you have to meet. And, you've got a provision in here that you get $1 billion termination fee. Why isn't that sufficient? Well, it's not sufficient because we won't make as much money. Well, that's not irreparable harm. That's just money. So that's my gut. So that's my gut of how I read it. Again, I got to admit my bias. I got to say I love Elon. I'm not a fan of Twitter's management either. But, we're going to figure this out. What's coming? As I understand it, it's going to take a ballpark 60 days for this to get resolved. It goes in front of a judge in the Chancery Court. There's some process that happens. It should happen fairly quickly, maybe 3 months. I don't think it's going to take longer than 3 months. It might be done in 2 months. And really what happens is at some point, Twitter is confronted with this reality, right? if they go through with this litigation and they win and they get $1 billion termination fee or a $2 billion termination fee, I heard the argument they would get $2 billion, but the stock falls, market cap falls by $10 billion, then they haven't really done a good job for their shareholders. And maybe it falls more than that. If, on the other hand, they renegotiate with Elon and save him $10 billion from $44 billion to $34 billion, but the current market cap is $28 billion, then shareholders are making out. Because what's going to happen to the stock if it actually goes through? They get $1 billion and the stock market cap falls another $5 billion. Shareholders get screwed. The board looks terrible. If there's an opportunity to salvage this deal for 5 or 10 billion less than the original deal, then that's better for the shareholders. It's better for Elon. It's better for the board. It's better for everybody. That's what I think is the likely outcome. But with the board playing butthurt, victim whininess, maybe they're so full of themselves that they forget that they're supposed to act in the interest of the shareholders. My gut is that they're going to act in the interest of the shareholders. Some kind of deal will be reached. The price will end up being, instead of $44 billion, and it'll be in $34 billion, something like that. And the deal gets done. That's a prediction, and it's not a firm prediction. It's just, that's my gut hunch as to what happens. So that's it. Different setting. I hope you liked the video. Please check out my other videos. Support the channel on the Locals platform, Patreon as a YouTube channel member. Check out the t-shirts. This means critical thinking in Latin. People love this shirt. Check it out at elonbits.com. And thank you so much for watching.